Hey everybody, how's it going? Welcome back to Copper Jacket TV. So like it or not, there's federal judges out there who do not believe in the Second Amendment. They believe that as long as the government has a good interest in infringing on your rights, then it should be just fine. As a matter of fact, we have an instance of a federal judge here that we're going to be talking about today that just upheld a so-called assault weapons ban because, well, he doesn't believe that they're good for defense, and he actually believes that they're used more likely for unlawful purposes than lawful purposes. You're just not going to believe what this judge has to say. So if you want to hear it, stay tuned. Now, real quick, I just want to say thank you all very much for watching. If you're watching this video and you're not subscribed yet, hit that subscribe button. We do videos pretty much every day during the week. Hit that little bell notification. That'll let you know when the new videos come out. It's free. It only takes a second, but it helps me out quite a bit. And check out the main sponsor of this channel down below, which is the USCCA. With your membership, you get that self-defense liability insurance, which is absolutely priceless. Okay, so let's go and talk about what's going on here. So, unfortunately, there always has been and always will be activist judges in our judicial system. As somebody who grew up in the state of California, I've seen it my entire life. I don't think there's ever been a case that's gone before the Ninth Circuit Court of Appeals that has upheld the Second Amendment for the people. No, they have always, and I mean always, sided with the state of California. And unfortunately, there's judges like that all over the country. Now, these judges, as long as it's within their agenda and the state gives a moderately compelling argument, will side with the state as well. And they will just simply infringe on your constitutional rights because of that agenda. And that's what we have here with Judge Janet Arterton, who has just upheld a so-called assault weapon ban for reasons that you will not believe. So let's go ahead and talk about what those reasons are. Okay, so let's just go ahead and read one of the paragraphs from the 74-page order that this judge gave denying an injunction against the so-called assault weapons ban in Connecticut. So the judge says here, as for the level of burden imposed, Heller did not foreclose any kind of restriction on the type of firearms that can be possessed and carried, or even restrictions on firearms that are commonly owned by lawful citizens. Only a ban on firearms that are so pervasively used for self-defense that to ban them would infringe or destroy the right to self-defense. Unlike the broader category of handguns at issue here in Heller and Bruin, the record developed here demonstrates that assault weapons and LCMs are suboptimal for self-defense, a set of statutes that only bans a subset of categories of firearms that possesses new and dangerous characteristics that make them susceptible to abuse by non-law-abiding citizens wielding them for unlawful purposes, imposes a comparable burden to the regulations on Bowie knives, percussion caps, pistols, and other things. So basically talking about the different stuff that has been regulated in history, particularly when there remain more than 1,000 firearms that Connecticut residents can purchase for responsible and lawful uses like self-defense, home defense, and other lawful purposes such as hunting and sport shooting. So yeah, you heard that right. The judge actually said that she believes that they are suboptimal for self-defense, which is actually what the defense was trying to say in their arguments. So the defense, being the state, was saying that they believe that they're suboptimal for self-defense. The judge parrots that and says that she believes that they're suboptimal as well. And so being the fact that they're suboptimal for self-defense and the fact that they're likely to be used for unlawful purposes by unlawful people, then any lawful person shouldn't be allowed to have them. And the fact of the matter is that it's really just a subset in a category that's being banned here. And since you still have quite a few choices at your disposal, right, they're not taking away absolutely everything from you, then it should be okay to keep this ban in place. That's what the judge is saying. Because you have other choices, then this choice really shouldn't matter if it disappears. Now, she says it's suboptimal. I believe that it's optimal. As a matter of fact, if I were given a choice, hey, pick this or pick this, I would pick what they're trying to ban to protect myself and my family. But again, she believes, somebody who obviously clearly knows absolutely nothing about them, that they are not a good choice to defend yourself. So like I said before, this is exactly what happens when activism trickles down into the courts. This is what happens when judges have an agenda and judges are seeing things through the light of that agenda and not through the lens of the Constitution, right? Which is supposed to, like I said in the very beginning, protect us from the government infringing on our rights, which is exactly what's happening here. The state is trying to infringe on the people's rights. The judges, these courts, are supposed to be there to uphold the Constitution, to let the state or the federal government know, hey, you can't do that, it infringes on people's rights. But instead, the judge basically looks at things and says, well, I got to find a way out of this because I don't really like these things. So we're just going to say they're not good for self-defense, and under Heller, they're just not, it's not going to hold up. And that's what we have here in Connecticut. And I am fed up with judges who decide that they're going to look at their own personal agenda over the Constitution. The Constitution is the law of the land, not your own personal belief. And we are not here at your will. The Second Amendment, again, it doesn't grant us anything. So you're not doing us a favor. It's supposed to protect us from them. That's the end of it right there. So I just want to let you guys know what was going on here. You know, I'm fed up with it. You see it all the time in the Ninth Circuit. Somebody who lives in Nevada now and used to live in California, I'm used to judges who think like this, but we need to get the activist judges out, and we need to get the judges who actually believe in the Constitution in. And, you know, we'd be able to overturn these types of things. So again, unfortunately, another ban has been upheld, and it's going to continue on, and I'm sure that if it gets there, it'll end up at SCOTUS, and we'll see what happens there, because they actually do, at least, you know, the ones who are conservative seem to recognize that our Constitution exists. So I wanted to let you guys know about that. Thank you all very much for watching. I do appreciate it. Please like, subscribe, and have a great day.